Thank you. Thank you so much for your kind introduction, but especially for your trust and for the opportunity to moderate this very important panel. It is true, it's my third conference, and I'm so happy to see that how the project has grown so far. I shared the exact same impression as Theodora, that 3 years ago, the use of AI in antitrust was still considered as experimental, and today it has become a reality, and it is thanks to Computational Antitrust project. Today, with our esteemed speakers, we will navigate you through the intricacies of the use of the AI by antitrust agencies. We will go through different examples of applications of AI in competition enforcement and analyze its challenges. I am thrilled to welcome our today's speakers, Maria Teresa Maggiolino, Associate Professor at Bocconi University, Renato Nazzini, Professor of Law at King's College London, Henrik Hofmann, Professor at the University of Luxembourg, and finally, Isabella Lorenzoni, a PhD candidate at the University of Luxembourg. If you followed us last year and 2 years ago, you might notice that the format of our panel has changed. There will be no presentations of the papers, and we'll start directly with the questions. So before I kick off the discussion with the very first question, allow me to briefly present the papers that our speakers wrote and that are either already available on our website or that will be published there very soon. The first paper was written by Henrik Hofmann and Isabella Lorenzoni, and they wrote about the future challenges for automation in competition law enforcement. The article offers an overview of how and when competition authorities apply AI in their enforcement. Henrik and Isabella list challenges that NCAs can encounter. They shed more light on the integration of automated decision-making into competition law enforcement and delve into the issue of human discretion and the principle of a right to a reasoned decision. Secondly, we have Maria Teresa Maggiolino and her paper on indeterminate antitrust concepts and artificial intelligence, the case of plausibility. The paper does a deep dive into the concept of plausibility in competition law and unpacks the potential of AI to help interpret the notion of plausibility. Maggie develops an idea that AI can help us construct on one hand, case-based notion of plausibility, and on the other hand, economic-driven notion of plausibility. Finally, we have Renato Nazzini and James Henderson, who wrote about overcoming the current knowledge gap of algorithmic collusion and the role of computational antitrust. The authors bring up the concept of algorithmic pricing and analyze the risk of collusive scenarios. Renato and James reveal how one should review algorithmic processing systems by introducing the techniques such as empirical and technical audits. Let me remind our participants that they are very welcome to ask questions in the Q&A section. Let's start the discussion with Henrik's and Isabella's paper. So in your paper, you talk a lot about the automated decision-making, the ADM, and since not everyone in the audience has read your paper, could you please give concrete examples of how the ADM can be implemented in competition law these days? You can also briefly introduce the concept, but I think we have already extensively talked about it in previous panels. The floor is yours.
Thank you very much, Thibault, and everyone for inviting us to this conference. In our paper, we discussed the use of automated decision-making, so the use of AI systems in general to the process of decision-making, which in general consisted of different phases, and AI systems can be used in each of these phases. In general, is not used for all the procedure. And if you think of a typical decision-making cycle in competition law enforcement, for example, the initiation phase, the investigation phase, decision-making monitoring, AI systems can be used in every of these phase. For example, in the initiation phase, some competition authorities already use screening tools with machine learning systems that are used as a proactive tools to raise red flags of unusual behaviors that might be an anti-competitive behavior. And in the investigation phase, for example, they use document management software to handle a huge amount of data, documents from the defendants or acquired during down raids. And here, this software, instead of using only basic keywords, they can function with more sophisticated AI systems, such as natural languages processing. For example, to identify documents protected by legal professional privilege or for privacy and data protection purposes. Then in the decision-making process, for example, past antitrust cases could be used as an input data to train algorithms and analyze elements that drove decisions in past cases. And this is also to ensure that similar cases can be treated in similar way. And finally, in the monitoring phase, advanced computational tools can be used to monitor compliance with certain remedies. And this might be useful when there are digital companies involved, for example.
Thank you, Isabella. It was very interesting. Thank you for walking us through the different phases in which AI can be used. I would like to direct my next question to Renato. With James, you focused on algorithmic collusion. It's basically automated decision making, but used by companies and not by antitrust agencies. Algorithmic collusion was on everyone's lips back in 2016 when Virtual Competition book was published. The book discussed the promises and perils of algorithmic-driven economy. But algorithmic collusion received some criticisms in academia, pointing out that there is no conclusive empirical evidence. So where do we stand now with algorithmic pricing and competition law? What has changed since then, and what's the state of play?
Thank you very much, Alexandra, and thank you very much to you and Thibault for the invitation. And thank you, everybody who is with us this morning or this evening. I hope you can all hear me. I think the point is exactly the one you made. I mean, I think we don't understand enough about algorithmic collusion and algorithmic pricing. We know that there is a lot of it going on, not only in e-commerce, where obviously we have now very clear evidence that any seller of any significance, probably about with a turnover of above 1 million, as we have references in the paper, etc. I mean, cannot do without algorithmic pricing. We do know that basically these prices for a product, I mean, there are millions and millions and millions of pricing changes every hour on the internet that have to be understood and potentially analyzed. So we quite simply don't have enough evidence, I agree, and we don't have enough evidence, I would suggest, one way or the other. We don't have enough evidence that there is pervasive algorithmic collusion and therefore a significant problem. Equally, we don't have enough evidence that there is no problem at all here, and we can just turn a blind eye to what is now a fundamentally pervasive sector of our economy. We certainly do have, I would suggest now, some good papers, not legal papers, because frankly, I'm a lawyer and I have been a lawyer for now the good part of almost 30 years, but I have to say that James Henderson, my co-author, is not a lawyer. By training, he's an engineer and a scientist, although he now wants to be a barrister, hence moving towards the law, but he has a scientific background. There is only as much that we as lawyers can say in this area, but the economic literature has identified, both empirically and in terms of models, settings in which algorithmic collusion can indeed take place. We have some examples in our paper, but for instance, Miklos, Tal, and Tucker, a very good paper in 2019, Collusion by Algorithm, and Whiting and Sapi as well, 2021 paper, and others. I don't want to do injustice to anybody. So one of the main points that we make, and I was very pleased to hear the carousel of competition agencies before. That was very interesting. One of the main points that I would make, we make in the paper, is that now competition authorities are starting equipping themselves with the tools to understand these markets better. We need to understand them better. We need the data. We need pervasive data. Obviously, not just a couple of bid rigging cases here and there. We need much more than that. It will not take weeks. It will not take months, maybe, but equally, it cannot take 10 years, because these things are happening now.
Thank you very much, Renato. My next question goes to Maggie, who also focused on tools, different tools that competition authorities can equip themselves to understand better the market. You focused on the notion of plausibility. So could you please tell us why you decided to focus on the notion of plausibility? And I think it's also a great opportunity to introduce the concept to our participants. Thank you.
Okay, thank you very much, Alexandra, and thank you, Thibault, and everybody else who is here. Yeah, well, when I decided to write the paper, I moved from a very simple observation that antitrust rules, much like any other legal rule and any other human language statement, do contain a lot of concepts whose meaning is uncertain, it is vague, it is ambiguous. Plausibility is one of them. Actually, people do not really know what plausibility stands for, what does it mean. And the reason why I give so much importance to plausibility is that it is present both in substantive and procedural rules, both in US and EU antitrust law. For example, consider that in EU competition law, when dealing with cases where only circumstantial evidence is available, cartels are deemed proved only if there is no other plausible explanation for the observed facts. Similarly, under US antitrust law, only claims that show plausible reasons to infer illicit behavior and considered worthy of further examination. And in substantive law, think that in new competition law, for example, in relation to the concept of potential competition, it is said that potential competition exists when it is plausible that competitors will enter the relevant market. So now this concept, whose meaning is indeterminate, is uncertain, is present both in procedural rules that aims at ascertaining, at detecting facts, and in substantial rules that somehow may have, or sometimes may have, also normative meaning, also the goal of driving the market, or the behavior of the human agents or firms towards some specific goals. So I thought that testing AI tools to interpret this notion that plays so many roles within antitrust law could be a good exercise.
Yeah, this is a very good point, and that's also I have a follow-up question about that, because when I read your paper, I realized like how important it is to have this objective understanding of plausibility in order to fairly apply the law. So the question is then, how can NI help with establishing an objective notion of plausibility?
Well, let me get started from a very simple idea. Right now, plausibility is used to dismiss scenarios that are perceived as mere possibilities or pure speculations, as opposed to scenarios that we perceive as normal, usual, common, ordinary, or even natural. Now, clearly enough, every human being may have different conceptualization of what is normal, usual, common, ordinary, and even natural. More importantly, This different conceptualization may result not only from objective facts, scientific laws, valid generalizations, but also from personal experiences, beliefs, prejudice, and even common assumptions. Therefore, as you were saying, we need a shared notion of plausibility, not only for the sake of fairness, but also to control and even rule out the amount of knowledge which is not rooted in hard science, or which is even the result of prejudice. Now, the question becomes, what can AI do in order to help us achieving this notion? Well, in my paper, I developed two possibilities. One way to develop this notion of possibility is combining string searching algorithms and natural language processing algorithms, unsupervised algorithms, to come up with a notion of plausibility that allows us to understand the factors, the parameters that antitrust decision makers, both courts and authorities, have historically employed over the years to define what plausibility is. And we can use these algorithms to understand, to assess the weight of these different factors, and also to classify them either among the factual elements or among those who are value-driven elements. And so, on the basis of the case law, we could use AI to create a bottom-up notion of plausibility that obviously is the result of what has been decided so far. Otherwise, differently, on the other hand, we could develop using what we call representation and reasoning AI, an economic-driven notion of plausibility, meaning we could develop algorithms that are based on economic principles and economic rules in order to develop a notion of plausibility that mirrors and reflects our economic understanding of what is usual, normal, natural, and so on.
That's very interesting. It actually reminds me of the fact that AI necessarily entails some challenges. And Isabella and Herwig studied in detail this question and different challenges of computational antitrust. So Herwig, Isabella, what do you think are the biggest challenges that competition authorities face and how to overcome them?
Thank you. I will take this question, Herwig, if you agree. I think that in this very moment, the biggest challenges that competition authorities face is a technical challenge, which is the lack of available data. For example, there was in the conference, in the ECN conference, it was said that there is a paradox between ubiquity of data and the scarcity of data. And the lack of data represent the main challenges, I think, for competition authorities. And this is in three different problems create. One is the fact that they don't have access to private companies' data. So the data such as cost, product quantities, because obviously companies are reluctant to share to competition authorities their data if they don't have an RFI. Another important problem is the lack of a complete and unbiased data set. So having a data set reliable, unbiased, with enough examples of collusion and non-collusion that they can rely on to train algorithms. And then another problem that came up by some competition authorities during the interviews that I conducted with some of them is the fact that they don't have structured data. So the problem to transform structured data that comes in with PDF format in a structured data readable for machine learning systems, for example, in Excel files, because otherwise they have to do that manually to transform all the data, all the documents, trillions of documents in PDF to Excel files, and this is a huge problem for competition authorities. And I think that to overcome this, one of the possible solution that has been suggested also in the previous panel is to cooperation, not only with competition authorities, but also with public authorities to exchange data. I think this might be important also in the light of the recent Data Act. And I think that also exchange data with academia, maintain the dialogue with academia can be really important, because scholars collect data for research purpose. They use it, of course, for research, for research purpose, but can be used by competition authorities in real case scenario. So I think that is the main way to go to overcome such issues.
Thank you for your contribution. I think this is a recurring issue in all of the articles, that the problem is the lack of data. And some of you make the argument that we need a lot of good data to make a meaningful change in antitrust enforcement. So my question, which is actually addressed to all of you, how can the agencies collect good data? And this is also, if you want to react to what Isabella just said. So do you think it's a good idea that agencies cooperate, and there should be some kind of data pool for agencies? I don't know, maybe Hervik, you would like to react.
Now, having data is, of course, absolutely necessary for any decision making, especially in the competition area, where we need market data, we need pricing data, we need comparable data out of certain areas. Even to identify a market, we need a lot of data simply to see, for example, how would price changes affect markets and so on. That's all well known. So far, the competition authorities have gotten along quite well, often also simply employing private expertise for that. When you look at availability of data for computational antitrust, using algorithms, of course, they rely on much more information than humanly was processed in the past. And the difficulty is, computational antitrust only has an advantage if it can increase the quantity of data and the quality of analysis by comparison to a human. That's the key why we want to have computational antitrust, where the advantages are. But in order to get that, one would need to either have more transparency on the market for the public enforcers. And it's an interesting, if you compare, for example, financial supervision with classic antitrust area. In financial supervision, more and more market participants are obliged to share nearly in real time their data with the authorities, and basically have authorities' software being plugged into individual data transactions. That's one way of doing things. Another way has just been mentioned, which is inter-agency cooperation. Their latest wave of European digital legislation, Isabella was mentioning the Data Act, but also there's an Interoperability Act coming up. It's a horrible mass of legislation at the moment in the pipeline. It's hard to keep up. But those types of approaches try to harmonize the way data are processed, harmonize the way data are reported, and therefore increase the usability as well as the data quality. Hopefully the quality, that is, because with poor data quality, of course, no good decisions can come out. And that's so far the biggest challenge, I think, next to the data availability, is to ensure the data quality.
Yes, you're completely right. Renata, what do you think about it? Do you think pulling data together is a good idea? Do you think maybe competition authorities should jointly develop the same algorithms to actually exploit the data better? What are the possible obstacles?
Yeah, I mean, I think that eventually some kind of data pooling from competition authorities is quite necessary, because we have seen that actually based on experience so far, it's quite difficult to get sufficient good data within a given jurisdiction. And of course, this is particularly problematic for smaller jurisdictions. So are we talking about the United States, or are we talking about, I don't know, the Netherlands or Switzerland, right? So obviously there will have to be a number of conditions for that to happen. So first of all, if competition authorities are to share data and good data, they have to get this data in the first place. Now, they can, of course, get it through their investigations. But for example, I mean, we have seen that so far, again, based on experience, yeah, there have been interesting cases here and there. And you have one of these cases, everybody in the world talks about it. But in reality, these cases about where AI tools have been used and etc. are still quite rare, and also, you know, data from cartels, you know, from the vitamins cartel, you know, are not necessarily very useful to detect nowadays cartels. So competition authorities need to get good data, including good data about online pricing and so on. So we have to think about, I believe, whether competition authorities should be given new powers, not necessarily in an investigation, but as was said before by Herbig, actually, to just find out, sort of fact-finding exercises in their own jurisdictions. This, of course, and especially if then this data is going to be shared with competition authorities outside the jurisdiction, this must come with safeguards in terms of possibly anonymity and use of this data, because of course we need also to protect the legitimate interests of those companies or those firms whose data are used, particularly if at the end of the day these companies have done nothing wrong. Remember that, you know, for example, to train algorithms as to whether certain online pricing is predatory pricing or is collusive or not, you need examples of collusive outcomes, predatory pricing, and also examples of perfectly legitimate prices. And the other thing I would say, we then need to be very careful in terms of adjusting this data to different market realities. And for example, there has been a recent study in relation to possible collusive outcomes in bidding markets in Switzerland and Japan. And what has been seen is that the kind of closeness of bids that would be consistent with the collusive outcome in Switzerland and in Japan is different. So in Japan, even in perfectly competitive settings, probably because there is more market transparency, for whatever reasons, bids tend to be actually closer to each other, and variances are lower compared, for example, to Switzerland. Now, this was studied and accounted for, so all is possible, but it's not straightforward, and one does wonder. I mean, I was in a competition authority, although now it's becoming quite a long time ago, I have to say. We weren't talking about computational antitrust at the time, but there is certainly an issue of resources and costs associated with all of that. But it seems, again, from the carousel before, that competition authorities are investing in this area now.
Thank you. I think it's very important to also talk about smaller authorities and they particularly face indeed the problem of scarcity of resources. And Maggie, I have a question for you now. In your paper, you talked about the driven and the case-based notion of plausibility. So since authorities face this problem of limited resources and they could only develop one of them, which do you think would be a bigger help to antitrust agencies?
Well, generally, I stand for the economic-driven notion of plausibility for a very, very traditional reason. If antitrust law is meant to protect the market well functioning, and if economics is the social science which is in the best place to explain the market well functioning, I believe that we should use economics to understand what is normal, usual, common, ordinary, in one word, what is plausible. So I think that as analyzing cases and with computational tools would be very costly for authorities, creating an economic-driven notion of plausibility by an algorithm would be easier and could be used in any jurisdiction, because economics is different from law as long as it is universal. What makes economic sense in the US makes economic sense in the EU, and so on. So this is the main reason, practical reason why, and even theoretical reason why one could stand for this economic-driven notion of plausibility. However, when we deal with plausibility and we introduce it within procedural rules, we use it to rule out scenarios which are not empirically possible. Now, economics is a value-driven science. I mean, it's not a piece of art science like physics, mathematics. It is imbued with the values. And so if we choose to use the economic notion of plausibility and to use it within procedural rules, it means that we select the reality that makes more economic sense on the basis of values, not only on the basis of facts. And this is a choice that has already been made by human beings in many cases, but still this should be a choice we should be aware of.
Yes, indeed. Isabella and Herwig also argued that the automated decision-making might limit human discretion of case handlers. So I wanted to ask you whether limiting enforcers' discretion is a good thing. Should we create any obligation for enforcers to explain the reasons why they decided to deviate from the outcome proposed by the AI?
So let me briefly go one step back before we start with discretion, because we have to think of, when we're thinking of public enforcement, obviously that's where this notion comes. We have to think of the fact that we want and we require from a decision to be properly reasoned. It needs to be reasoned with regard to the exercise of all of the requirements which go in, and also the procedural requirements. So it needs to show the market analysis, the reasoning. It needs to show what wrongdoing has occurred and what problems came out, and how the facts are linked to the outcome, and how that is overall a proportionate decision in the context of these facts. So that makes the overall discretion. The discretion happens within the procedure at many points. It's the discretion of the choice of selection of the investigation tools, and it's a choice of economic models to analyze. Even though the courts review that aspect a bit more, they still grant a certain amount. And then it comes to the decision and the outcome and so on. So we have discretion on a whole spectrum of elements. Discretion is not a unitary element. So when we look at this whole spectrum, de facto, when we have computational antitrust, when we have tools which allow for an analysis of markets, for example, or of the analysis of certain anomalies of market behavior, these might have a very persuasive force, and therefore lead de facto to an officer in a case handler to suggest a certain outcome, because the individual, the human, would not have the possibility to de novo review all of this fact analysis, which is done by the computational analysis. So even if theoretically the human would have the possibility and the right to override and decide differently de facto, and with all the pressure of time as well as, you know, the risk of outcome. If a case handler, an officer says, listen, this is what our well-calibrated AI system here suggests, and I follow it, is on the safe side, or she, and if she would deviate, she might be subject to a lot of internal pressure, even, you know, even if she could analyze all of those pre-requirements herself or himself. So de facto, there is a limitation of discretion if you have complex analysis of complex facts by a automated system. What's the way out? The way out is to ensure that there's transparency in the individual decision as to what is the input and what is the output and why are they related, which has to be programmed, by the way. And we have to make sure that our computational AI systems actually allow for this knowledge, which in the moment is very rarely the case. And the other thing is that we understand what is actually the software in the AI tool. It is similar to administrative rulemaking, to soft law. We have internal administrative guidelines, right? That's de facto what it does, because it makes these abstract terms, which Maria Teresa was describing, more concrete towards an individual decision. So it has the same effect as administrative rulemaking, and so therefore, at least in legal systems where we have transparency requirements for those administrative rulemaking structures, that should also be applied in the area of computational antitrust.
Thank you. I think it's very important what you said, and it actually made me think about the procedural rights and whether the current competition procedural rulebook is actually well made for the developments, for the recent developments that we are observing right now. So it's a question that is addressed to all of you. Could you think of one procedural right that should emerge with the development of AI? And of course, being creative and original is very welcome here. Renato, maybe you could go first.
I mean, certainly. I mean, but I'm not sure it's a new procedural right, but so I think we have. I mean, we already have principles there. So first of all, proportionality, of course, because this is going to become more important, because potentially, if competition authorities are embarking upon more kind of intensive investigations, then into pricing and pricing patterns and the workings and functioning of algorithms, I think that is going to be quite important. I mean, the other one, which is controversial, I think, and I'm not sure whether it goes a little bit against what Henrik and Isabella are arguing. I mean, is there a right to a human being making decisions about our business, our life? I mean, this is a problem that arises, of course, in competition law, but arises in all sorts of other areas of law. Is there such a right, or can a firm or can a company insist on a human decision maker? And if we delegate procedural decisions about maybe plausibility, I mean, which is an element of decision making, as Maria Teresa was saying. So, is entry plausible? If this effect on the market plausible? I mean, a case can turn on these issues. Can we delegate it under the current law to AI? And of course, because AI was not there when our administrative law systems emerged, there is obviously no express rule against delegating these things to AI, simply because, I mean, certainly speaking about it in English and also possibly Italian and administrative law, I mean, there is I don't think there is any such rule, but I mean, there are certainly rules about the right to judicially review decisions, including procedural decisions, for example, for lack of reasoning. And if we give these procedural decisions and other substantive decisions to AI, I mean, does AI provide reasoning? Generally not, right? And what type of AI do we use? I mean, it can even be a kind of self-learning algorithm, which is a completely black box. It says yes or not. So do we have to think about systems whereby, I don't know, for example, a little bit like the settler, again, I'm trying to be imaginative, as Alexandra said, you know, can we then think about a system where companies can choose whether to go down the AI route, or but they can assert a right to human decision making if they want to. I don't know, but I think this is not just in competition law, but more broadly, this is going to be, and certainly there are areas of the law where the issue is much more serious, like criminal law, etc., family law, and so on. But I mean, it's quite fundamental to me.
Maggie, I saw you doing a gesture of approval during Renato's contribution. So could you please react to his contribution, and also answer the question: what is the new procedural right that should emerge with the development of the AI?
Well, I agree with Renato, and I try to think as if I were a firm under scrutiny. If somebody took a decision against me by using an algorithm, I would like to understand how the algorithm plays and how the judge or the administrative authority use it. So the role that the algorithm play in giving me that result. So how would you call that right? Right of transparency, right of unboxing the algorithm, right to understand the reasoning of the court, of the authority, and to be subject to a fair judgment. Now, because in my understanding, and probably I'm a boomer, so I'm not the right person to be questionable, but in my understanding, these are tools that should empower us to be more powerful in analyzing reality, in giving fairness, not tools whereby we should delegate our responsibilities to computers or something else. So that's my understanding of how we should use them in order to make our job the better possible, not in order to make it more complex for companies that want to exercise the right of defense, or for consumers that want to understand how authorities spend their money to protect the functioning of the market. I don't know whether I was clear, but the idea is these are tools. I'm not a great supporter of the idea that they should take the place of human beings.
I see. I think Renato also mentioned at some point that maybe competition authorities should be equipped with new competences, and the question about procedural right has the other side. So right now the question is, what kind of competences should competition authorities get with the development of AI? What do you think about that? Renato, do you have anything that you could think of?
No, I mean, just very briefly, I mean, actually picking up on what Herwig was saying before, I mean, certainly I think that because of the use of AI by firms, by companies, competition authorities should be given not that much more competencies, I'm not sure, but maybe more powers, or different powers, because I mean, it would probably be also wrong to say more powers. I mean, competition authorities have now adequate powers to ask for information, etc., in, let's say, the traditional economy. And to a certain extent, these powers can be interpreted to suit this new digital economy as well. For example, the European Commission actually carried out what we would call an empirical audit of the Google algorithm in the Google shopping case. So they input data into the algorithm to see whether actually it really did manipulate the outcomes or not. But I do think that first of all, as Hendrik was saying, because of the difficulties in understanding these markets, probably more fact-finding powers and maybe reporting powers in high-risk areas. I mean, we have seen, for example, the AI Act. I mean, there was recently a political agreement, as I understand it, in the European Union on it. I mean, the AI Act, if ever adopted and implemented, we expect it will be, does categorize activities in high risk and others. So, for example, shall we think about also in the competition area, the competition sphere, about high risk activities and kind of reporting obligations, or quite simply powers to be exercised by the competition authorities. Again, we have the tools, market studies, market inquiries. So regardless of suspicions of infringements, but just in order to better understand markets, powers to carry out audits, empirical audits, technical audits of algorithms. Are they already under the existing powers? Maybe, maybe not. Should it be clearer? Should we be clearer on the one hand in giving competition authorities these powers, and on the other hand, clearer about the procedural safeguards that also apply, because these powers are not quite exactly the same as the ones that we know about.
So one of the aspects...
I wanted to ask you, Herwig, for your reaction, so please go ahead.
No, I don't. I think Renato is absolutely right. But you know, Isabella and my paper was about analyzing what's going on in the area of computational antitrust, and looking at whether we're not actually perfectly well equipped with traditional tools from public law and more specifically competition law. And I think we are actually very well equipped. They just have to be properly applied in the context of computational antitrust and the increase of data amounts we simply have. And in that context, one of the maybe newer principles or obligations one should impose on market participants is a certain amount of data retention, something you have for other areas of the law, you know, whether it's telephone companies or banks and so on. So that if there is an investigation at a later stage, data doesn't have to be reconstructed about some market somewhere, which is virtually impossible. But the companies under investigation will have to show their data for a certain period of time as to how they reacted to certain markets. And then it can be reconstructed, possibly also with AI systems, which have maybe been fed with machine data, of how other markets might have reacted. And that might be giving indications as to problems which have occurred in the context of whichever specific area, goods or services market one is on. But this data retention obligation doesn't exist, but that is one of the elements we have been talking about right at the beginning of this session, of how to actually get the data to feed the AI systems or the automated decision-making systems in this context. Just one other remark on the data. It's interesting actually to see that now generative AI systems are becoming much more powerful and will develop much faster. There, the black box question is not even an issue anymore, because these generative AI models are trained to large part on just general data. And knowing what training data went in or how they work doesn't help us to see what individual decision these powerful tools are suggesting. There it again becomes ever more important, as Maria Teresa was saying, transparency is then the tool for holding antitrust authorities to account.
Thank you. I also, your contribution made me think about the recent Facebook Ireland case where Facebook actually argued for privacy arguments, and it was rejected at first, but we'll see how the case continues. Isabella, would you like to react very quickly to what Herwig said, and then I will give back floor to Thibaut.
Yeah. So I think that in general, what is the possible procedural right? And to conclude, I was thinking actually to be more concrete on having auditing officers instead, because I think that sooner or later, as you all said, competition authorities are starting to equip themselves with much more powerful tools, and even if right now they are just taking baby steps or taking a little bit slowly. You, Eric, mentioned generative AI that are becoming much more spread out. I think that this will be the way to go also for computational antitrust, for competition authorities. And this is why I think that transparency should be guaranteed also with the use of experts, both at the internal level of competition authorities by having, for example, auditing officers to review in general the AI process and the systems that have been used, but also that might be important to how the outcome of AI systems are presented in court to ensure effective judicial review. And also there, it might be necessary to have experts, to have some judges that are trained to read interpret the outcome of an AI, not just from the side of the systems, but in general for ensure transparency and for ensure effective judicial review of decisions, since as you all know, sooner or later AI will be used much more by competition authorities, and it might be necessary to explain much more in depth the results of an AI in courts and for the defendants.
Thank you so much. Unfortunately, our time is up, and Thibaut asked me to give him back the floor. Thank you so much for this panel. Thank you so much for sharing your take on AI and antitrust. It was a terrific panel. I was very happy to moderate it. Thank you, participants, for being with us today, and back to you, Thibaut.
Thank you, Alexander.
Herwig, you mentioned what should be, I think, not could, but should be the name of a paper: transparency, transparency, transparency. That will make for a great title, maybe for even a book. So the link to your paper is in the chat. If you're watching this video on YouTube, let's say in 2040, you can go to computationalantitrust.com. I'm sure the website is still running and access their paper. And by then, Maria Teresa and Renato's paper will be also published. So to all of you, thank you very much. For all the participants in the chat, thank you for staying up so late if you are in Europe, and or for launching with us if you are in the United States. Before I let you go, two very quick things. Number one, you can actually go to Codex website, and I will encourage that you do so, to not only check computational antitrust, but also what computational law may enable in other spheres. And what I wanted to say is that we are back tomorrow. The program is on the event page, but to go through it very briefly, we have a keynote by Glenn Vell and Zoe Hittig on how to combine computational antitrust and principles of democracy to come up with a new way to think about antitrust. Then we will hear about researchers that have used computational tools to actually produce some results that you may want to hear about. We have a computational carousel to mirror the agency carousel that we had today, in which you will hear from two companies, not sponsors, but just great companies that we thought you should hear about indeed what you can do with the computational tools. And the very last panel will be computational antitrust in practice, in which is a first for us. We've combined competition agencies, practitioners, and academic and someone working for a company, namely Google, talking about what they use, which tools they use, the challenges they see. So again, thank you so very much for staying up so late, and we'll see you tomorrow, same time as today. And take care of yourself, and if you can, someone else too. Bye-bye.